Court is calling 2024 CR 009936, State versus Carrie Lampkin. Are you Carrie Lampkin?
All right, folks. Get ready because what starts off like a routine court session is about to spiral into something far more dramatic. We're diving into State versus Carrie Lannon. And trust me, this isn't just about legal procedure. It's about pride, pressure, and a defendant ready to take the courtroom into her own hands. Let's see how that plays out.
All right, could you raise your right hand for me, please? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God? Yes. All right, you can lower your hand if you'll state your name for the record.
Carrie Lampkin.
All right, I'm going to ask you some questions, and the questions, thank you. The questions that I'm going to ask you are related to your representation. It's not about the facts of the case. If it were about the facts of the case, then the state would need to be here. This is just a determination of whether or not I find that you should be allowed to represent yourself, okay?
And there it is. She says kint probably, meaning colloquate, which is the formal conversation between judge and defendant when someone pleads guilty. But hey, she's confident in court. Confidence is half the game, right? Well, not if it's paired with confusion.
It's like qualified.
Qualified? A what?
Qualified. See if I'm to represent myself.
Yes. All right. So how far did you go in school?
I mean, currently in school right now. Should be graduating this year now. I'm now getting behind the finals because.
All right. So here's the thing. The best thing about being a witness and what attorneys always tell witnesses, just answer the question that's asked of you.
Okay.
So, how far are you in school?
College now.
All right. What year?
I'm pursuing sophomore / junior.
All right. And what are you studying?
Law.
All right. And how many years have you studied the law?
I say about 5 years.
All right.
But it was in the school edition and family law.
So, have you ever studied criminal law?
I never had a desire to learn about it until now that I'm going through this.
All right, so remember what I said. Just answer the questions. Have you ever studied criminal law?
This moment says it else. She admits she's never studied criminal law. That's huge because representing yourself isn't just about guts, it's about understanding the stakes. When you step into court without a lawyer, you're expected to know the rules, just like a professional. And the court it won't cut you much SL.
I've never studied criminal law, but based on my study, it's like all civil in nature.
All right, so here's my other question for you. Do you understand you have a right, because this is a criminal matter, you have a right to have an attorney appointed to you if you cannot afford to hire an attorney? Do you understand?
Yes, ma'am.
All right, so do you want to have one? Can you afford an attorney?
That's
yes or no?
At the moment, no, because of
All right, then the next question. Here's the thing. Just listen to the questions, all right? Are you able to afford to hire an attorney?
No.
All right. Would you like an attorney appointed to you? That's either yes or no.
But I'd be able to speak to counsel, like someone from my counsel, to be able to make a decision. I don't want to just rush and say yes and no when I don't.
Watch closely. She's still trying to negotiate her own terms, but courtroom deadlines aren't suggestions. They're final. Judges don't entertain endless back no forth. And right here, the judge has clearly had enough. It's either trial or plea. No more detours.
No, I mean, here's the thing. You don't get a chance to choose who your attorney is.
Yes.
My question for you is, and I just want you to answer my questions.
Yes.
Would you like to have an attorney appointed to represent you? That's either yes or no.
Your Honor, I'm sorry. I just feel like I'm being pressured and rushed, and I don't.
No, you're not being rushed. This case has been going on since January 2025. Let me explain something to you. When this case comes to trial, it is going to trial.
Yes, ma'am.
There's not going to be at the last minute, I decided I don't want to do this. Let me get an attorney and get another reset. That's not going to happen. So my question to you is, do you want an attorney appointed to you? That's either yes or no. If your answer is no, whatever ends up happening, you end up representing yourself, then you're going to represent yourself. I'm not going to give any resets, because in the middle of trial, you decide you're over your head and you need an attorney. That's not going to happen.
Your Honor, with all due respect, my attorney,
Here's the thing. Don't start with all due respect. And let me just tell you why. No. This is what I want to tell you. When people say with all due respect, they're really getting upset. And usually what comes after with all due respect is not with respect. It's like when people say, let me be honest with you. Usually what's coming is not honesty.
I'm so sorry. I wasn't trying to go that route.
No problem.
I was just wanted to say with all respect, Your Honor, the reason why I withdrew from my attorney, there was an issue with discovery since day one.
Okay, here's the thing. I don't get into things about you and attorneys and what happened with your previous attorney unless your previous attorney is here to give their side of things.
Yes. So, like again, Your Honor, so I'm not afforded my due process.
Now, the real heat begins. She's frustrated talking about pressure, due process, and missing evidence. And let's be honest, her emotions are valid, but in court, emotion without strategy rarely changes outcomes. And this judge, she's cool, direct, and doesn't bend easily under pressure.
I don't know, it's like if you're making a judicial decision.
It's not. It's either you want an attorney to represent you.
It'd be nice, Your Honor, if I could have some time to make that decision.
No.
Because I don't want to make the right decision if I'm going to defend myself. I'm already having lack of discovery.
My answer to you is no. If you want an attorney appointed to represent you, that attorney is going to be appointed today. You're going to meet them today. If you don't want an attorney appointed to you, then one will not be appointed to you. And your next setting is going to be a jury trial. And when you come in, it's going to trial. That's where we are. And I'm going to tell you again, previously, when you were saying you were filing your bill of particulars, I am not going to be an attorney for you. I'm not going to show you how things legally should be done or the legal process, because the last time you were here, I was helping you with your motion to say, is this what you mean? I'm not going to do that anymore. I'm just going to look at your motion. And if your motion is not in the proper order, if your motion is not asking for appropriate things, it's just going to be denied. So it's not going to be my job to walk you through questioning of witnesses. I'm assuming if this goes to trial, the state is going to call witnesses. It's not going to be my job to help you cross-examine them. It's not going to be my job to teach you the rules of evidence or criminal procedure. That's going to be all on you. And if you're not following those rules and the state objects, and it is an appropriate objection, then it's going to be sustained.
Yeah.
So
asking for legal advice, or
you have been, though, because the motions that you've been filing.
Legal reality check. She filed a bill of particulars meant to clarify the charges against her. But here's the problem. Her filing missed the mark badly. The judge is basically telling her, if you're going to act as your own lawyer, you better act like one. This is courtroom chess, not checkers.
Have not been appropriate motions. Your bill of particulars, when I read it, it's really not a bill of particulars.
Like, I'm trying to be respectful as possible, Your Honor. There's applying pressure on me to make a decision. Everything is moving fast here. Like, I don't consent to go to jury when I got my due process has been violated. I'm praying that you can hear me out. It seems like you're pushing me into making a decision without.
No, so let me just explain something to you. Your attorney was here at the last hearing. Your attorney said that he's already shown you all discovery and you received it. And here's the thing, you're saying that's not true. But listen to me. Put on your listening ears. This is what I'm telling you. Your attorney, the attorney that you hired, your attorney said that they gave you all the discovery. Sometimes people receive discovery and they don't like what they're seeing. That's fine. That attorney is a good attorney. That attorney has not had any violations, no ethical concerns by this court or by the state bar. That attorney said that you had already received all of the discovery. That attorney even has a portal on his website where his clients can go in and look at the discovery that he's received. He said that you've already received that. So you're coming to me saying that you haven't received discovery. Your attorney says you have. So, nope, let me stop you there. So what I'm telling you is this is going to trial, and you're standing before me saying that you have not received discovery when your defense attorney says, I have given you the discovery and I have no reason to disbelieve your attorney. Your attorney has never given this court any reason to disbelieve him when he says that you have received discovery. Their question, and this is the last time I'm going to ask it, and you can answer it. If you don't want to answer it, that's fine. This case has been on the docket since January. What I am telling you right now is you will answer yes or no. If you don't want to answer it, you don't have to answer it. Do you want an attorney appointed to you? Yes or no? All right, that'll be no. Ms. Ferguson, place this on the jury trial with Judge Angelini on June 16th.
So I'm not going to talk.
Sure, you can talk. Go ahead.
So I have placed on the record, Your Honor, substantiating evidence of proof that I have not been able to receive discovery. On May the 3rd, I received an email of some more discovery that my attorney said. After I filed a motion to withdraw from him. The only reason why I filed this motion to withdraw from him is because of the lack of discovery. Since day one, you know, Your Honor, every time we came here, it was for Your Honor, the file's too big. Oh, Your Honor, I don't have, I haven't got it from Jason. Oh, Your Honor, he's had to come in and buy a hard drive. But he made me and his client get a hard drive to go get it, and he still didn't give it to me in a hard drive. Your Honor, I have substantial evidence to prove my facts, and I have submitted it, I have filed it in the clerk with the clerk. So if he's willing to say what he said to the record, if he sent me discovery, I would love, Your Honor, if he could do a sworn affidavit stating what he said, so it could be put into.
He's an officer of the court, so he doesn't have to do a sworn affidavit.
Yes, I understand, but I put the burden of proof. I showed the burden of proof, Your Honor, of my facts. I'm showing you that I did not receive discovery until Saturday, 2 days before trial, 2 days before court hearing. If you can look in the system, you'll see I have to do a statement signed by a notary that I signed under perjury, under swore in, under perjury. I'm not trying to go to jail for lying. I'm telling the truth, Your Honor. He did not give me discovery until it was on Saturday. That Saturday before court. And it's a good child. And how could you miss that? He did say something before. No, Your Honor, 1 month, 2 months out, 2 weeks after that, 1 month after. It's like he's been piecemealing this stuff to me. Then he's saying we're on the files to me. This will make me make the decision to withdraw from counsel because he's not the best fit for me. Maybe other attorney, he's not probably the good fit for me. And this would make me want to represent myself. Because I wanted an attorney. After I went through 6 months with dealing with him, and I was very patient, very patient. I didn't say a word. I didn't get upset with him. He wanted me to take a plea deal before I even got discovery. And that's what really made me not upset, but made me really concerned because I'm like, you're representing me, but you want me to take a plea deal without me having discovery?
And this is the emotional peak of the entire hearing. Carrie's voice shakes. She's overwhelmed. She feels pushed into a plea without full discovery, without time, without trust. And whether she's right or wrong, you can feel if she no longer believes in the system. That's not just legal tension. That's personal raw courtroom drama.